Is there a difference in the level of scrutiny towards rulings of criminal law and towards criminal law? And if so, why? Criminal law and civil law addresses different levels of civilian life, but both attempt to keep order and regulate the actions of citizens. And so, if both parts of the Canadian law try to promote justice through court rulings and punishments, we ask, is there a difference in the level of scrutiny towards rulings of criminal law and towards criminal law? And if so, why is there a different level of scrutiny? Moreover, how can justice be served if there are different levels of standards for different laws? So, what is civil law and criminal law aim to address and regulate? Well, prior to fully discussing if there are differences in the level of scrutiny, and if so, why, we will first speak about what each law is addressing and attempting to regulate. To begin, criminal law is about acts either very harmful or severe, such as treason, terrorism, prohibited possession of firearms, and more. And these acts pertain to acts committed against the Crown and/or the general public, meaning by committing these acts, you are potentially threatening, risking, or directly harming members of the society. In other words, any major action that extremely negatively affect others in any community would be considered a violation of the Canadian Criminal Code, and that would be found guilty. On the other hand, civil law is about personal issues between individuals or private companies that either require a third party to unbiasedly evaluate whether a person is responsible. Specifically, civil law includes regulations for labor, family, property, contract, and tort. To expand, tort refers to an act or omission that gives rise to injury or harm to another and amounts to a civil wrong for which courts impose liability, such as defamation, economic malpractice, privacy, motor vehicle, and wrongful dismissal. In other words, civil law attempts to regulate personal issues that may cause harm and to find a person liable and to what degree, or balance of probabilities, that person is liable. Severity of the implications. One important aspect to understand is that the severity of the consequences of these acts or omissions greatly differs from each law. In civil law, especially indictable offenses have punishments of the loss of rights, freedoms and liberty. A common example is a jail sentence, where someone who is found guilty of committing a criminal act would have to serve time. This time is essentially stripped away from these convicts, as these prisoners don't have many rights or freedoms, and that time is limited, something that cannot be regained or earned. As such, to the Canadian legal system, jail sentences are considered the greatest punishments. While in civil law, the plaintiff can only demand compensation. In many cases, it is in the form of money. The major difference between these punishments is that money is something that you can earn and get back, but losing your liberty and time in your life is irreversible. Standards of certainty. And so we find that there is a difference in the level of scrutiny towards rulings of criminal law and towards civil law. In criminal law, each jury and judge is required to be 95% certain to be able to believe the accused is guilty, and the jury is required to unanimously decide on a ruling. While in civil law, each jury and judge is required to be 51% certain to decide the defendant is liable, and only 75% of the jury must agree that the defendant is liable. People think that laws are black and white, but this system has a large gray area. For example, O.J. Simpson was found not guilty in criminal court, but was found liable in civil court for wrongful death. This shows that judges and jury members thought that O.J. Simpson was above 51% liable, but below 95% guilty of his crimes. This can lead to lots of questionable people having lots of questions about the law, as how can someone be not guilty of a crime but then have to pay money in fines because they committed the crime. To conclude, we asked, how can justice be served if there are different levels of standards for different laws? And to answer these questions, we first looked at how civil law and criminal law attempts to regulate different levels or severities of crimes and whether or not the act or omission was against an individual or against the public. Secondly, we addressed the severity of the implications and how in criminal law the punishments were the removal of liberty, while in civil law the punishments were physical and replaceable compensations for the defendant. And because of the difference in penalties, we found that the standards of certainty reflected the severity of these punishments. Thank you.